بسم الله الرحمن الرحيم الحمد لله رب العالمين والصلاة والسلام على سيدنا محمد وعلى آله وصحبه أجمعين اللهم اجعل جمعنا هذا جمعا مرحوما واجعل تفرقنا من بعده تفرقا معصوما ولا تجعل فينا ولا منا ولا معنا شقيا ولا مطرودا ولا محروما اللهم أنزل علينا من رحماتك وسكينتك وأفضالك وإنعامك برحمتك يا أكرم الأكرمين وبعد فالسلام عليكم ورحمة الله وبركاته. I know it's very hard to be awake after a heavy meal and after a heavy presentation, but inshallah we'll keep you entertained as much as possible. This is your brother Basim Hamidi from Houston. So welcome to Houston, welcome to the H-Town as we call it, and Jazakumullahu khairan for taking the burden to travel from all over the country to our beautiful city. This topic, inshallah, is going to be a very important topic, very practical. We've already had a lot of discussion about it. It's going to be about the civic divorce, and the extent of Islamic validity of that divorce. I just want to remind you that at 4 o'clock, inshallah, we're going to have the most practical and maybe the most awaited topic, which is the prenuptial and postnuptial contract agreement for marriage, something the AMJA has worked extensively on. And we had a panel of 3 people that worked enormously, put a lot of effort in it. So I really advise you to attend that session. There is going to be a panel discussion starting at 3:10, so whoever had a question, inshallah, you'll have plenty of time to ask questions. Without further ado, I invite Sheikh Dr. Furhan Zubairi to present his topic. Jazakumullahu khairan.
السلام عليكم ورحمة الله. بسم الله الرحمن الرحيم. الحمد لله والصلاة والسلام على رسول الله وبعد. All thanks and praise are due to Allah subhanahu wa ta'ala, and may His peace and blessings be upon His last and final messenger, His family, His companions, and those who follow them until the end of times. Respected teachers, elders, shuyukh, and imams, may Allah subhanahu wa ta'ala bless you for taking time out of your very busy schedules to be part of this very beneficial and beautiful program. May Allah subhanahu wa ta'ala reward AMJA and the entire team for organizing such a beautiful and beneficial program every single year. May Allah subhanahu wa ta'ala place this on our scale of good deeds on the day of judgment. So today I'm going to be discussing the topic is civil divorce and the extent of its validity as an Islamic divorce. Meaning a civil divorce that's granted by a secular court, does it count as a talaq or not? So I'm going to be summarizing the findings of 3 different papers. The first is entitled Civil Divorce and the Extent of Its Validity as an Islamic Divorce, which I authored. The second is Marital Discord in Islam, a jurisprudential perspective by our beloved Dr. Ali Ahmed. And then the third is Shar'iyyu Talaq al-Madani, وَمَا يَتَرَتَّبُ عَلَيْهِ جَوَازًا وَعَدْبًا by our beloved Dr. Mamduh. So I'm going to present the findings of each paper individually, and then I'll highlight areas of agreement and disagreement. So when it comes to my paper, I explore the complex intersection of Islamic and civil law, specifically regarding marriage and divorce. I investigate the Islamic legal status of civil divorces granted by non-Muslim courts, specifically the question of whether such divorces count as a valid talaq. I tried my best to examine the different perspectives on the issues, including the opinions of contemporary jurists and fiqh councils, and analyzed the legal arguments and the practical implications for Muslims in non-Muslim countries. The ultimate conclusion is that a civil divorce granted without the husband's consent is generally not considered valid under Islamic law. All right, again, a civil divorce granted without the husband's consent is generally not considered valid under Islamic law. So I open my paper by first defining the terms. So we go through a definition of an-nikah, the definition of civil marriage, the definition of talaq, and the definition of civil divorce. And the reason for going through these definitions is to highlight that each of these is an independent reality. They're all referring to separate essences and realities. Because a civil marriage and a nikah, they are coming from different backgrounds and different perspectives. Legally, philosophically, socially, morally, they have different frameworks and different paradigms. So although there might be a lot of overlap, they are two separate realities. And the same thing goes for a civil divorce and a talaq as well. So after defining the terms, I tried to highlight the similarities and differences between nikah and civil marriage. So both civil marriage and nikah establish legally recognized unions, involve contractual agreements between the parties, require the consent of both individuals entering the marriage, and carry legal rights and responsibilities such as inheritance, property rights, and spousal support. For a civil marriage to align with the Islamic concept of nikah, it needs to fulfill the Sharia requirements. So this includes a proper offer and acceptance, the arkan, the ijab and qabul, and the presence of the required witnesses during the marriage contract. So the conclusion is that a civil marriage does not always equate to a nikah. Although there is definitely overlap, a civil marriage does not always equate to a nikah. It can if it fulfills the Islamic requirements. The arkan and shurut of a nikah have to be met. So there has to be ijab, there has to be qabul, there has to be the presence of two witnesses. Depending on which school of thought you're following, there has to be kafa'a, this compatibility, the suitability between the spouses. Depending upon which madhab you're following, there has to be a wali, a guardian involved as well. So a civil marriage, it can potentially count as a nikah as long as the Sharia requirements are being fulfilled. I then explored the differences between a civil divorce and talaq. And the conclusion is that there's no inherent equivalency between a talaq and civil divorce. So a civil divorce does not equate to an Islamic talaq because the dissolution processes in Islam, especially talaq and khula', which have been discussed, necessitate the husband's consent. A civil divorce doesn't require the husband's consent, highlighting a fundamental difference in the two systems. So in order for a talaq to be valid, one of the most important components is that the husband intends it and the husband is the one who's pronouncing it. Because the talaq essentially is a unilateral right of the husband. So when it comes to a civil divorce, that aspect oftentimes is not being fulfilled or it's not being met. Because if the husband contests the divorce, or if the wife goes and files without the husband's knowledge and he doesn't respond, and a judge goes ahead and dissolves the marriage civilly, it will not always again equate to a Islamic divorce or a talaq. I then went and presented the differing opinions on the validity of a civil divorce as a talaq. So according to most contemporary scholars and fiqh councils, there are only limited circumstances in which a civil divorce can be treated as a talaq. The first is when the husband and wife apply for a joint uncontested divorce. Number two, when the husband files for divorce. And number three, when the wife files for divorce and it is uncontested by the husband. So as I mentioned, a talaq is a unilateral and exclusive right of the husband. For a talaq to be valid, it must be pronounced by the husband verbally or in writing. The husband may also delegate the right of divorce, tafweed al-talaq, to his wife or a third party. And he may also appoint a third party as an agent on his behalf to pronounce the divorce, which is known as tawkeel, right? Appointing a wakil, appointing an agent to pronounce the divorce on his behalf. So when a husband files for divorce individually or jointly through the civil court system, it can be framed as him appointing the court or the judge as his agent to divorce his wife. In simpler words, it can be understood as tawkeel al-talaq. And when the court declares the dissolution of marriage, it will count as one talaq raj'i. I have a mistake in my paper. I put as a talaq ba'in as an irrevocable divorce, but Sheikh Zahid, Jazakallah khairan, he pointed out it should be talaq raj'i. It should be a revocable divorce. Similarly, if the wife files for divorce and the husband consents by knowingly and willingly signing the paperwork, it can also be considered as tawkil, and when the court declares the dissolution of marriage, it will count as one revocable divorce, talaq raj'i. Then we get to the issue of a contested divorce. So the overwhelming majority of contemporary scholars and fatawa, they contend that a civil divorce doesn't constitute a valid talaq when the husband contests it. And this stems from the principle that non-Muslim authorities lack jurisdiction in Islamic matters. La wilayata lil kafir ala al-Muslim. I essentially summarize Dr. Yusuf Wahab's paper titled Secular Court-Ordered Divorces, What Modern Fatawa and Canadian Imams Say. So in this paper, Dr. Wahab, he analyzed 15 fatawa that were issued by governmental and non-governmental bodies across the world from the years 2000 to 2021. And they give an opinion on whether a secular divorce contested by the husband counts as a valid Islamic divorce or not. I listed the position of 13 out of 15 because 2 of them were from Shia bodies. Now 12 out of the 13 fatawa conclude that a secular court-ordered divorce does not count as a valid form of Islamic marriage dissolution when the husband contests it. For the divorce to be Islamically valid, the husband must issue a verbal or written talaq separately. The only fatwa that disagreed, the only fatwa that said a civil divorce contested by the husband counts as talaq is a fatwa issued by the European Council of Fatwa and Research. They suggest that when a Muslim couple registers their marriage under a non-Muslim legal system, it implies the husband's consent to grant the civil court authority over their divorce. Dhimnan. I have put their entire fatwa both in Arabic and English in the paper. Please do reference it so you can see where they're coming from. So again, the only body, the only authority that says a civil divorce granted by the court that's contested by the husband counts as talaq is this European Council of Fatwa and Research. So just to summarize, according to most contemporary scholars and fiqh councils, there are limited cases in which a civil divorce can be treated as talaq. Number 1, when the husband and wife apply for a joint uncontested divorce. Number 2, when the husband files for divorce. Number 3, when the wife files for divorce and it is uncontested by the husband. The majority of contemporary scholars and fiqh councils argue that a secular court-ordered divorce does not count as a valid form of talaq when the husband contests it. For the divorce to be Islamically valid, the husband must grant a verbal or written divorce, agree to khula', or the wife should pursue securing a fasakh. And I know that creates certain challenges. In certain cases, in certain instances, there are examples of perhaps where the wife is being left as someone hanging, kal-mu'allaqa. And there are other problems, other issues involved. And the only avenue she has of getting a divorce is through the courts. Even in that situation, it's important for her to have recourse, to have access to an Islamic council, an arbitration council, that based on the facts of the case, based off due diligence, could perhaps grant a fasakh or tatliq, as was discussed earlier. And to facilitate this, I highly recommend Islamic prenuptial agreements, which I believe is the next session, inshallah. Right? I strongly recommend that Muslim couples establish a prenuptial agreement that outlines a method for divorce acceptable under both Islamic and local civil laws. This proactive measure aims to mitigate potential conflicts in the future. You know, I have been serving as an imam, as a teacher since 2011, and I've performed hundreds of marriages and nikahs, and I can probably count on my hand the number of individuals who have a prenup. And I think it's important for us as imams, as community leaders, to make this something more common. This should become the norm, especially when we perform marriages in our masajid, in our institutions. We should highly encourage the new couple to enter into a prenuptial agreement. That is going to help mitigate, that is going to avoid a lot of the conflict, a lot of the acrimony that rises at the time of divorce. And I believe there are a few institutions, a few organizations that have templates for a prenuptial agreement according to Islamic guidelines, and I believe AMJA is publishing one, inshallah, as well. So I would highly recommend that we make the norm in our communities, inshallah. Number two, and this has been mentioned before, coming up with Islamic alternative dispute resolution institutions. That, I know a lot of Imams, a lot of scholars that might be doing this independently, but it's important to have formalized institutions under the guidance of perhaps national organizations that can have a standardized procedure for Islamic dispute resolution, of course including at-talaq. I then quickly summarize our respected Dr. Ali Ahmed's paper, Marital Discord in Islam, a Jurisprudential Perspective. It discusses the exact same topic from pages 28 to 31. It discusses civil divorce and the extent of its Islamic validity. There's a lot of overlap between Dr. Ali's paper and mine. Dr. Ali also concludes that a civil marriage does not equate to an Islamic marriage, and similarly, an Islamic marriage does not equate to a civil marriage. A civil marriage will only count as an Islamic marriage if it fulfills the Sharia requirements. And similar to my paper, Dr. Ali also highlights that an Islamic marriage can be terminated in one of three ways: at-talaq, al-khul', and fasakh. He then summarizes the opinions on whether a civil divorce is equivalent to an Islamic divorce. It seems like both of us use the same sources for our discussion, and that's why there's a great deal of overlap. He also mentions the opinion of the European Council for Fatwa and Research and the opinion of the majority of fiqh councils across the world. He essentially presents the same conclusion, but with a very important difference. And that's something that I did not address in my paper, and that is the issue of intention, the issue of an-niyah. That when the husband files for divorce in a civil court, he should also have the niyyah of talaq at the same time for it to count. Similarly, if it's joint, if it's being filed jointly by husband and wife, the husband should also have the niyyah, the intention, at the time of filing. And the same thing for an uncontested divorce. That if the wife goes and files and he does not contest, his intention should be to pronounce a talaq as well. So I will read what he writes. He says, however, it is important to note that just as a civil marriage does not bring about the consequences of an Islamic nikah, similarly, a civil divorce cannot bring about the consequences of an Islamic divorce except in the limited scenario where, number one, the husband applies for the civil divorce with the intent of also effecting an Islamic divorce, and two, all requisite conditions for an Islamic divorce were met according to Islamic jurisprudence, such as lack of coercion, sanity, and so on. The crucial point of intent must be taken into consideration before concluding that the Islamic marriage has also come to an end. It is not sufficient that the husband initiated the divorce, as his motivations could include various other reasons, such as dividing or separating assets, safeguarding the wife from financial harm due to bankruptcy procedures, tax incentives, ensuring that inheritance is distributed according to Islamic principles, or taking a second wife. Additionally, if the husband accepts the wife's petition for divorce without contesting and signs the divorce decree, this action alone is also insufficient to effectuate an Islamic dissolution of marriage. Various factors could influence such a decision, including pre-planned financial incentives, coercion, deception, or financial incapacity to contest the divorce. Therefore, merely signing the divorce papers without contest does not necessarily indicate the husband's intent to initiate an Islamic divorce, and I fully agree with that. I would fully agree with that conclusion. The researcher also argues that for a civil divorce to be equivalent to an Islamic divorce, the husband's explicit intent must be present when finalizing the divorce. In the absence of such intent, the divorce should not be considered valid under Islamic law, and the wife would continue to be legally married to the husband in the Islamic context. And then very quickly, for Dr. Mamdouh's paper, شرعية الطلاق المدني وما يترتب عليه جوازا وعدما, he also speaks about essentially the same issue. He opens his paper by defining civil divorce. He then discusses to what extent a civil marriage and a civil divorce are recognized by the Sharia. He also has a section where he discusses to what extent a khula' or separation granted by an Islamic center because of harm will be recognized by the Sharia. And he has several conclusions that he lists out explicitly. That civil divorce can be recognized if it aligns with the goals and criteria of the Sharia. Civil marriage without meeting Islamic criteria is not valid Islamically. Civil divorce does not necessarily equate to Islamic divorce unless the husband willingly signs the legal papers with the intention to divorce. The role of Islamic centers is crucial in educating the community about the invalidity of civil divorce if it doesn't meet Islamic criteria. Khula' or divorce for harm can be granted by Islamic centers or Imams, and civil divorce should then be documented for legal recognition. I know I did injustice to both of your papers. Everyone, please do read them. They're of great, great benefit. Take the time and absorb what's being presented. We ask Allah subhanahu wa ta'ala to make this presentation of benefit. May Allah subhanahu wa ta'ala grant all of us tawfiq. And it seems like we're all in agreement essentially. Inshallah. Jazakumullah khairan. Wassalamu alaikum wa rahmatullah.
MashaAllah, this is phenomenal. We finished like 8 minutes early. This should be the prototype of how a presentation should be given, alhamdulillah. Since we have a presentation of our co-sponsor Baytul Mal at 3:05, we're going to take a couple of questions, inshallah. And unless Sheikh Mamdouh and Sheikh Ali want to comment on their papers, please go ahead. I think just to do it justice, I think you have to comment on it.
Jazakallah khair. Mufti Furhan, may Allah bless you and honor you. May Allah subhanahu wa ta'ala increase you in knowledge along with all of us. From a qada'i perspective, I made a recommendation. And this recommendation, I'm sure that if we were to implement this recommendation, then we will leave the disputed area and adopt a procedure or a position that no one can deny. And that is in order for us to avoid these ikhtilafat, I think it's very important that the Imams and the scholars who are adjudicating such cases, that they take the most safest and they take the most universally accepted interpretation, one that cannot be challenged in the future, whether by other scholars or even the husband if he tries to claim her as his wife. And that is the issue of intention. Now, a lot of us, we might say, well, you know, al-qadi yahkum bil-zahir wallahu yatawalla as-sara'ir, which is correct. That a qadi, he will go ahead and make a ruling based upon the apparent, and Allah he knows what is hidden. But it is upon the qadi, or one who's acting in the capacity of the qadi, that he investigates it with the husband and says, what was the intention behind your uncontested signing of the papers? After gaining such clarification, only then can a qadi say, yes, this is a valid Islamic, this counts as an Islamic divorce, or no, it does not, depending on how he responds. So this is just a suggestion that I humbly made in this paper, and I hope, inshallah, that we take the safest and the most universally accepted. So that way, he does not go and get another ruling from someone else, and now you have two rulings that are opposing each other, and so therefore no maslahah was really brought to this marital dispute. Allah knows best.
Jazakallah khairan. I just want to point out that what Sheikh Dr. Farhan has presented as the European Council counting the civil divorce as valid, it was based on one paper by one single researcher, our beloved Sheikh Faisal Mawlawi rahimahullah. And that was the only individual actually paper presented, as far as I know, in the world validating that divorce. Sheikh
taking it from there, actually the European Fiqh Council just went in details, if you read it on their website, that they differed between the people who did their marriage overseas and the people who did their marriage in Europe. And that will create another problematic issue. What about the people who are married overseas and over there? And then they did the civil divorce over there. Like here in the United States, not necessarily, you don't have to be necessarily married here to file for divorce here. So that fatwa will not apply. Although there are a few other problems, and the problems with the wife who just do not want the husband for any reason, and then she just wanted half of his wealth, and the man has no fault, and then she goes there and she gets divorced, civil divorce. And then the husband does not sign the papers, does not want to recognize the divorce, and he wants his money back. He considered it as a khula. She is the one who got out from the marriage, but she considered it as a divorce. After that, she goes to another Islamic center, and she presents another marriage license. And then she does another Islamic marriage. And I have that case here in Houston currently, at this point now, for almost a year now. And the wife went and married someone. She took about a couple of $1 million from the guy, and then she recognized this as a divorce. And then she went and obtained a civil marriage divorce in Houston. Then she went to another Islamic center, and she got married based on that. They did not even ask if you're divorced or not, you divorced Islamically or not. And then the husband now is just going around and saying, what's my status now? So that is where I said in the paper, there have to be actually a follow-up for that. There has to be an arbitration for that. If a husband comes in this case, what do we rule? Because there is another marriage now in effect. What do we rule? Do we rule by the European Council, or we say that this marriage is valid, or we say that the wife is having issues, hence you give her divorce? Then you go after that in the civil court, try to somehow get your money back. It's a complicated issue. Also in my paper, I also emphasized on the fact that arbitration or reconciliation that happens, or mediation that happens before going to the court. And now many people started doing that. Of course, premarital and postmarital agreement, they are great, but for those who did not have it, which is the majority right now, you are going to be preventive when you deal with this coming lecture. This is for marriages to happen. But what about marriages happened already, and they do not want to have a post-marital agreement? What happens then? So when a divorce happens, Islamic centers and imams should advocate for, come here, we are going to give you a good agreement, which is called an MSA, Mediated Settlement Agreement, or NSA, a Negotiated Settlement Agreement, collaborative, whatever it is, this ADR, Alternative Dispute Resolutions, and then you go take that to the court, and the court approves it. And Texas law, for example, agrees with that 100%. There are many judges took agreements that I made. They never asked a question. They just asked them one simple question. Did you agree on this? Are you aware of everything here? I grant you divorce. And that happens. And also we summon or look at the nafaqat al-mut'a as one of the options or alternatives to transgression from the husband's side, not giving the wife what she deserves. She lives 20 years or 30 years, and she does not take half of his wealth, but Islamically, her mu'akhar is $50, or $100. Then what does she do then? Then we invoke nafaqat al-mut'a up to 3 or even 5 years of spousal support based on her need and his ability. So those are issues I mentioned in the paper, and those are issues that would be recommendations for the AMJA, inshallah, to look at and come up with, inshallah, tawsiyat for the final resolution, inshallah.
Jazakumullahu khairan.
Door. As soon as you come outside, depending which door, to your left or to your right.
Jazakumullahu khairan. Now we move to the panel discussion with open Q&As, and we're going to start with the same system, inshallah. The sisters, then the brothers. Any sister has a question? Yes, please, come to the mic and address it to a particular speaker if you'd like, or you can leave it open. And we're going to limit the question to 90 seconds precisely, inshallah.
Bismillah. This question is for any of the scholars. أي واحد من المشايخ الكرام الأفاضل. Unfortunately, as we know, divorce is very, very messy. and causes a lot of harm on both sides. Okay, as we know, divorce is very messy, causes a lot of harm on both sides, regardless who is at fault. And since it's easy for the husband to file for divorce and continue the divorce process, I'm going to be focusing on the woman's side. So if a wife is being harmed in a marriage, and we see this sometimes unfortunately, and she initiates the divorce because she's being harmed or she's being treated as mu'allaqa, and the husband is ignoring her, he won't file for the divorce. And if she files for divorce and he refuses to sign the divorce, he refuses to cooperate, he refuses to do any type of mediation with the mashayikh, refuses mediation with any of the institutions right now going on. So if she initiates the divorce and he ends up signing the divorce papers in the end, or if the court actually decrees the divorce and he does not legally contest it or legally appeal it, is that considered an actual talaq? يعني هل وقع الطلاق أم لا? And
So that's one question.
that's one question. The second question is with the issue of the husband needing to have an intention when he files for the divorce. So if a husband files for divorce or he signs the divorce papers, and the one of the mashayikh mentioned he actually has to have the intention for it to be a valid divorce shar'an, isn't his action of filing the divorce pretty much like or comparable to talaq sarih? And so his intention wouldn't actually be needed, because then years later, after she remarries and has children, he can come back and say, oh, actually, you're still my wife after the divorce. I never intended the divorce. Barakallahu fikum.
That's clear. Jazakallahu khairan.
بسم الله، الحمد لله والصلاة والسلام على رسول الله. أعتقد أن الأخت الكريمة قد أجيب على سؤالها من خلال الأوراق المقدمة، وإخواننا أبدأوا في هذا وأعادوا وقدموا وأكدوا مرارا وتكرارا على أن للزواج عقدتين: عقدة مدنية وعقدة شرعية. العقدة الشرعية يملك أن يحلها الزوج أو القضاء الشرعي. العقدة المدنية عند القضاء المدني، وعند صدور التطليق المدني ينتهي الجانب المدني الرسمي القانوني في العلاقة الزوجية، وتبقى العلاقة الشرعية موضع نظر. طيب، عندما نأتي بعد هذا الزوج تقدم وعمل فايلنج للطلاق. الناس يفعلون هذا لأسباب كثيرة، من بينها إنهاء عقدة الزواج الشرعية، ومن بينها ترتيب أوضاع نظامية له متعلقة بالضرائب، متعلقة بالجوازات، متعلقة بالسوشيال سيكوريتي، متعلقة برغبته في الزواج في الارتباط بزوجة أخرى، في تفادي أوضاع ضريبية أو أوضاع مالية. ثمة أغراض كثيرة ومقاصد كثيرة أخرى غير إنهاء الجانب الشرعي. ومسألة الزواج لا تبنى على ضبابية، ولا تبنى على ريبة، ولا على ظن. نحن نقدر أن المرأة تحتاج لأن يبت في أمرها ويحسن. لقد سمعت أختنا وهي قادرة على أن تتكلم بالعربية، لكنني الحمد لله لقد فهمت ما قالت. يعني تقول: ماذا تفعل المرأة إذا قدمت بأوراق الطلاق من جانبها وزوجها رفض، وأنتم لا تعتبرون التطليق المدني تطليقا، فماذا تفعل؟ أولا، المحاكم المدنية لها بروسيجر تنتهي به في النهاية إلى أن تمنحها وثيقة تطليق مدنية وافق الزوج أم أبى. يعني لا يتوقف صدور الوثيقة المدنية بالتطليق على موافقة الزوج. عندهم بروسيجر قد تختلف قد تعقد، قد تزداد طولا، لكن في النهاية ستمنح وثيقة مدنية بالتطليق. تأتي بهذه الوثيقة إلى المسجد، إلى الجهة الشرعية، تنظر فيها. وتعليق على مسألة ذكرها لي أحد إخواننا الفضلاء من السادة الحضور، قال: هل المسجد بيصدر وثيقة تطليق شرعية اوتوماتيكلي تلقائي بصورة عفوية تلقائية على الوثيقة المدنية؟ نبقى طبعا ما عملناش حاجة. يعني إذا كان الموضوع إن بس بيعمل توقيع من غير ما ينظر، يبقى هذا إجراء صوري لا قيمة له. لا، هو المسجد بيبتدي ينظر في الحالة عشان يكيفها. هل نحن أمام خلع، أمام امرأة بطلت معيشتها وتكره زوجها بدون مسوغ شرعي، أم أمام تطليق للضرر؟ فيتصل بالزوج ويعمل تحري حول الحالة ويفتي فيها أو يفصل فيها بما يريه الله عز وجل. فأختنا تصبر نفسها قليلا إلى أن تصدر الوثيقة المدنية بالتطليق، عندما تأتي بها إلى الجهة الإسلامية لتبدأ إجراءاتها، وينتهي بها الأمر إلى ما تريد إن شاء الله. والصبر نصف الدين، الدين نصفه صبر ونصفه الآخر شكر، والعبد ما بين عبوديتي الصبر في الضراء والشكر في السراء. أسأل الله لي ولكم التوفيق والسداد.
جزاكم الله خيرا. Brother, go ahead.
Thank you. So my first question, and this goes to anyone who wants to answer it, inshallah. Earlier, it was mentioned that infidelity in itself does not lead to divorce. Now, the question is, at what point does infidelity becomes a valid reason for divorce? That's my first question. My second question is relating to what the sister asked earlier. In this case, both family refuses to agree. Like there's a woman who wants to divorce because of harm or whatever the situation is. The husband refuses to give her a divorce. Both family, meaning her side of the family and his side of the family, refuse to come to agree to a divorce. The wife lives here in the United States. The husband lives in another country. The parents of the wife goes ahead to curse literally any family member who decides to step in and actually ensures or work through the divorce. So now the wife is basically in a limbo. And in this case, what situation or what advice would you give? And lastly, if a parent refused to bless...
That's it, brother. 2 questions.
I think I've been standing here for a long time. Can I get one more? Because the
You're
first
not
question was
guaranteed to get an
with the
answer.
previous panel. And
Okay.
that's why I had this one, please. This is a very... I'm from New York, from the African community, and
keep
it's a
going.
very important question for us. In a situation where 2 young people find each other, they want to get married, and the parents refuse to bless them for marriage. And again, go to the extent of cursing anybody who decides to approve this marriage. What advice would you give in this situation? What should these young people do? And as Imam, what advice would the Imam give the young people? Thank you.
Jazakallah khairan.
You allow me, sir? For first question, of course, marital يعني zina or committing a major sin is a ground for seeking divorce. Of course, we want a reconciliation, especially if there is tawbah, if there is counseling, if there is really a good intent from the offending spouse that they repented to Allah Azza wa Jalla and all of that. We advise them to continue the marriage for the sake of the marriage, the sanctity and the children, all of that. But if they insist, of course, it's a ground for marriage, and then remains the issue is how you're going to consider it. Is it khula, the wife is asking, or is it talaq, the husband is doing it, or is it darar, if she says that, I'm harmed in my Islam and all that. So that remains the issue, but it is a ground for that. For the second one and the third question, I have to separate between few things here. One is the emotional aspect of it, whoever is cursing, whoever is saying this, whoever is saying that, blessing marriage, not blessing marriage, that is beside the point. And the other thing is the legal issue, and the third thing is the Islamic issue. So if the husband and wife, a man and a woman want to get married, but their family is not blessing them, is it the boy's side, the man's side? Is it the woman's side? If it's the woman's side, then there is an issue of the wali, whether it is adl or not adl. Adl means forestalling, means the father or the wali is invoking his, guardianship as a way to prevent his daughter from marrying someone suitable to her without any justification. That's called the adl, forestalling. So if he does that, then this is an issue you have to deal with as an imam. Do you marry her without her guardian, if all the guardians like that or not? But if it is the man's side, there is no issue, whether his family agrees or not, whether they're cursing or not. If she is a good match for him and he's a good match for her, they want to get married, alhamdulillah rabbil alameen. So that's that issue. Husband is overseas and the wife is here and she wants to get divorced. Again, she goes to the court and do the procedure of the civil marriage. And once the civil marriage is done, we're going to follow the procedure of the Islamic marriage, try to contact the husband. And I tell sisters all the time, Islamic divorce, can sometimes take from 3 to 6 months. They come and they call every day, Sheikh, is there any new thing? Sheikh, is there anything? It's like kids in the car, are we there yet? Are we there yet? It doesn't work like that, this is a divorce, for God's sake, this is a divorce. Okay, so you go to the court, they are not gonna even look at it for 60 days. The judge will not even look at it. It's nothing until 60 days. And when it comes to Islam, it's not gonna happen in a week. So we call the husband. If he does not reply, or if he denies her right and everything, and there is an abuse involved, and there are medical records and all of that, that's talaq lid-darar. We divorce for the harm. And if she is the one who said, I give up everything and all of that, this is khula. Whether he agrees or not, we are going to grant khula. If he says, all right, I'm going to divorce her, alhamdulillah rabbil alameen. So we have to separate between those two things. What the court does, whatever it is, still the husband has to be approached. Whether he intended, whether he did, unless there is a clause in the agreement of the mediation or the arbitration says, by signing these papers, both parties agree that Islamic divorce will be valid. Islamic divorce will be executed upon the endorsement of the judge. If this is written there, then yes. But if it is not written there, she went, he went, both of them went, we have to ask them, do you intend that? Because writing the papers is from kinayat al-talaq, not from sarih al-talaq, as the sister mentioned. Kinayat al-talaq, not sarih al-talaq. It's not sarih al-talaq that he went and he filed and he signed the papers and he hired the lawyer. All of this does not mean that he agrees on divorce. Agrees on divorce, he has to say, I agree on divorce.
Jazakallahu khairan, Sheikh Mamdouh. Please go ahead, brother.
Assalamu alaikum wa rahmatullahi wa barakatuh. Just I have a very quick question to everyone, and Sheikh Mamdouh referred to that. We have a situation of a woman came to the masjid and her husband or the person that they're going to get married to, they have a marriage license. She said, I was married before and here's my divorce paper and all the records are good. And they got married in the masjid. A year later, we found the ex-husband coming in the picture and saying, I didn't divorce her, she forced me into all of this, and there's domestic violence and all kinds of cases like that. And they were married in a different country, in a Muslim country. And they said, I need the paper because I have the marriage is valid in this country, and I need to file a complaint in my home country against the woman. So that's the story. There are 3 questions out of this. There's a question 1, what should the wife do and what is her Islamic Sharia position now? And number 2, as a masjid or as an imam, for an incident like this, the ex-husband wanted the paper. Is the imam can give the paperwork that's a copy of the marriage license in the state and the marriage divorce and also the marriage license in the masjid? And number 3, what is the advice for the masjid to avoid such incidents to happen in the future?
Jazakallahu khairan.
اللهم لا سهل إلا ما جعلته سهلا.
So I shook my head.
يا مفهم سليمان فهمنا ويا معلم داود علمنا يا رب اللهم آمين. على كل حال أيها الحبيب، إذا اتخذت الإجراءات بصورة صحيحة فنبني عليها مواقفنا ولا ننظر إلى ما خلفها بعد ذلك. يعني إذا كانت الزوجة إذا كانت الزوجة قد حصلت على تطليق مدني ثم جاءت به إلى المسجد، والمسجد قام بدوره على النحو المرسوم شرعا، حاول أن يتصل بالزوج مرة بعد مرة بعد مرة، ووثق هذا في وثائقه، وأمسك بهذا في ملفاته، وأشهد على هذا من حوله، أخذ إجراءات صحيحة. فإذا لم يتجاوب الزوج أو عاند أو أصر، فأصدر المسجد وثيقة طلاق شرعية أو تطليق شرعية، فالإجراءات صحيحة. يبقى لا ينظر بعد هذا إلى ما جد من أمور أخرى، لأن قضاء القاضي يرفع الخلاف، لأن حكم المحكم يرفع الخلاف. أما إذا حدث خطأ في الإجراءات، يعني المسجد بمجرد وصول الورقة ليه راح مصدر وثيقة طلاق شرعية غيابية بدون محاولة الوصول إلى الزوج ولا التفاهم معه، هنا خلل إجرائي يجعل إجراء المسجد باطلا، لأنه إذا وقع بمجرد حصوله على الوثيقة المدنية أصبح الإجراء أصوليا لا قيمة له. إيه قيمة أن يذهب إلى المسجد؟ أن المسجد ينظر في المسألة نظرا شرعيا، ويعمل تقدير شرعي للموقف، ويبني موقفه وقراره بناء على ذلك. إذا اتخذت الإجراءات صحيحة فمن بنى عليها صحيح، والزوج من بعد هذا السابق يعني يفعل ما يشاء أمام المحاكم، يفعل ما يشاء، ويعني وعند الله يجتمع الخصوم أو القضاء، الوضع الذي يملك سلطانه ويملك إنفاذ قراراته سيكون هو المرجع النهائي في نهاية المطاف. هذا الذي يمكن القول في هذا. فقط أرجو ألا يعجل المسجد بإصدار وثيقة الطلاق الشرعية قبل أن يستكمل إجراءاته التي تجعل وثيقته التي تصدر بعد هذا مبنية على مقدمات صحيحة. إذا صحت المقدمات صحت النتائج، وإذا فسدت البدايات فسدت النتائج. وأسأل الله أن يقينا وإياكم الفتن. وهذا طريق شائك، يعني من أراد أن يعرف أنه من ولي القضاء فقد ذبح بغير سكين ينظر في هذه المسائل. فعلا ذبح بغير سكين ولغير القبلة كمان. أسأل الله لي ولكم العافية.
Go ahead, sister, please.
Assalamu alaikum warahmatullahi wabarakatuh. Barakallahu fikum for your wonderful presentation. I had a question for Sheikh Furhan. I wanted to get some clarification in the third point that was mentioned, that a woman who seeks a civil divorce and it's uncontested by the husband, that could be one of the cases where it's considered a talaq. And I wanted to get some clarification why that wouldn't be considered a khula', and if khula' is actually possible through a civil court. Barakallahu fikum.
Bismillah ar-Rahman ar-Rahim. So with respect to the first question, so when the wife files for divorce and the husband does not contest it, then essentially he is, if he gives the intention of talaq, it will count as talaq. It would only count as a khula' if they go through that process separately, where they actually have a mutual agreement where she's going to give back some sort of financial consideration and he accepts it. And according to the Ahnaf, they use like the actual terminology of khula' involved in it as well. So they could structure it like that. If they so wanted, if the husband wanted that, and he says that, you know what, I'm not granting you a talaq, but we should go through the process of khula' instead, they can agree to that, and whatever terms they agree on will be accepted. I don't remember what the second question was.
If she can do a khula' in the civil court, which I think you just answered.
Okay, yeah, they're connected. If anyone wants to add on. Yeah.
If issue is like the husband's consent can be interpreted in more than one way. The husband uncontesting can be interpreted in more than one way. And wallahi, I'm going to tell you honestly, in the past 2 years, exactly 2 years, I wake up every morning wishing that I do not hear the word talaq. But I do. I end up doing. Wallahi, akhwani, and I'm just telling you the truth. Talaq, khula', fasq, talaq, tatliq, you know, all abuse, all of that is like part of my daily, yani it's like a fourth meal for me, you know. So, la hawla wa la quwwata illa billah. فيعني husband not contesting Sometimes the husband is ignoring the whole situation, does not even recognize there is a civil court. Like he said to his wife, do whatever you like, I'm not recognizing any of that. And I got one of those cases. You talk to me, don't talk to me. I am the only one who can divorce my wife. He lives in a Muslim country and she is here and she is struggling. I'm not recognizing any of this. I'm not even recognizing any of you, the shuyukh of AMJA or anything like that. So him not contesting, sometimes he's just being quiet. So you have to ask the husband, and you have to email, you have to do that as Fadilat Sheikh mentioned. And once this is done, you've done your procedure, then you can divorce. But I see the issue when the husband is uncontesting it and the wife runs with it and say this is a talaq, that would be a thorny issue here. Allahu alam.
طيب جزاكم الله خيرا. We're going to take the last question.
Subhanallah.
Inshallah. You are the lucky person.
Alhamdulillah. Alhamdulillah. See, مع الصبر, when you're patient, you get something. Alhamdulillah. Very quick. The intention, the niyyah and talaq, is it because we are in a non-Muslim country and non-Muslim ruling, or that might apply in the يعني في البلاد الإسلامية? Because حتى لو في بعض some محاكم they don't go with the Sharia. And because he asked the question, if I'm sorry to ask, to clarify the question from the brother, if the masjid signed the paper like, but without doing his job, his diligence, then what the consequences of the second marriage? They have to go to what you call لازم يطلعوا مع مسامحة يطلعوا يعملوا بحث في الموضوع and they come to an agreement, or just automatically the second marriage will be declined and she must go back to the first husband.
Bismillah ar-Rahman ar-Rahim. So it seems like all of the questions that are being asked is probably due to the lack of comprehension of what Sheikh Dr. Salah Usawi is actually trying to convey. So if you allow me, let me just simplify what Sheikh Salah Usawi is saying. These are two different contracts that serves two different objectives. The objective of the nikah is istihlal al-furuj. That's it. The objective of the civil nikah or the civil marriage is is it istihlal al-furuj? No. It is about financial incentives. So this is istihlal al-furuj. This is financial incentives. The dissolution of this contract will not have an effect on this one. And the dissolution of this one will not have an effect on this one, because these are two different contracts that serves two different purposes. So whichever one you want to see the outcome, go ahead and process the procedure for that particular contract. So if you want to have financial incentives, if you want to save your family from bankruptcy, ramification, all of this, then you know what to do. But if you want to do istihlal al-furuj, if you want to dissolve the marital bond, then you cannot use this to justify this. This has this procedure which no one can tell the qadi, it's been 2 days since I applied, why haven't you given me a divorce? Even in China, they have 6 months cooling off period, meaning once you apply, the judge doesn't even look at it for 6 months. Come back after 6 months, cooling off period. This is their procedure. And as qada, we never ever are influenced by emotions. We completely remove emotions when we are adjudicating cases. Because if you have emotions involved and you are swayed by this party or that party, then you can imagine the mafsada that will occur. So to answer your question, Yani if a person wants to divorce his wife, tell him to follow the Islamic procedure. That's it. No need to bring up the civil process, none of that. You want to divorce? Come divorce in an amicable, with ihsan, with goodness. You both make dua for each other. You go ahead and go your separate ways. You make dua that Allah gives you someone better than her and Allah gives her someone better than you. You talk about co-parenting issues. You talk about outstanding financial issues. You talk about these things and alhamdulillah, go forward. Move forward. But for us to put this in here and this becomes messy and then therefore this becomes messy, it doesn't need to. There are cases that have taken 9 years in the civil courts just to get dissolved. 9 years. I have personally cases 1.5 years. Why? Because I have to follow the Islamic procedure. 1.5 years. Just like no one can blame the civil courts why you're taking 9 years. No one can blame the Islamic procedure why is it taking more than 1 month. It has its procedure. And those that are the ahl of that procedure, who are specialists in that particular field, they know what they're doing. And so when you have entrusted such individuals with the dissolution or the conclusion of your marriage, then know that eventually your marriage will be concluded one way or the other. You just need to allow them to follow the correct procedure. So that way, and I keep on mentioning this, because I would say the past 4 years, I've taken, and I'm not saying this because I'm proud, I've taken 950 cases in the past 4 years. I would say about 50 of those cases are those cases in which the husband is still claiming the wife to be his wife because the masjid that she applied, they have two prices. One price is about $350 or euros or pounds, which says it will take about 6 months. But if you want to have fast track, you pay $1,000. We'll give it to you in 3 weeks. Wallahi, I'm not joking. And so she applies for the fast track khul, and she gets it within 3 weeks. The only thing that the husband gets is a letter saying that because you have made darar or harmed your wife, we hereby dissolve your marriage unilaterally, without giving him the chance and the opportunity to hear his side. So he is screaming at the top of his lungs saying, you guys didn't give me, you didn't hear my side. You didn't follow the procedure. You didn't even follow the reconciliation process. I'm still going to claim. So now I had a case in which a wife had 2 husbands. 2 husbands.
Before we hear more serious stories, we're going to conclude inshallah here. Subhanaka
So let me just
Allahumma
conclude with this. The reason she had 2 husbands, and this case was with me for 2 years. Yeah. For 2 years. We're trying to establish the whole chronology. What happened, the reason this is happening is because when a masjid or a council does not follow the correct procedure, then at the end there is more mafsada that arises because of his or their short-term maslaha approach.
Jazakumullahu khairan, everyone. Just to remind you, our most important session is at 4 o'clock. You're going to hear a lot of work that has been done by AMJA that would resolve these issues, that's the prenuptial and postnuptial. There is a break till 4 o'clock, inshallah. Subhanaka Allahumma wa bihamdik. Nashhadu an la ilaha illa anta nastaghfiruka wa natubu ilayk. Ice cream. Don't scream though, please.
I'm done, huh? I'm done. No more. I was